answer it by saying, do you remember the movie War Games, in which they two young students get on the computer, they start a game called Global Nuclear War, and this machine starts playing this war game. Whopper at the end draws a conclusion that the only way to win the game is not to play.
Mm.
That's kind of my approach to legalities. I think the question, is it legal, has really a question, is it fair? Lawsuits where you were named as individuals when you were acting in the capacity as owner of the business. You may have gone to lawyers and you may have set up a business so that you would be protected personally. Now, nonetheless, when you're named in a lawsuit, you're named as a company and you're named as an individual. And therefore, typically, if you're incorporated, the corporation needs an attorney to represent them. And then you as an individual need usually a different attorney to represent you. So in some ways, it's kind of a double whammy.
Mm-hmm.
The process of being served a complaint is interesting because they have to deliver it to your place of business, if it's a business, and they can leave it with anybody that's over 18 years of age. This is a process of being served, and you as an individual have to be served. I had occasion to be sued recently. In early January, I got a call from my partner saying, I got some papers and I need you to see them. There are too many to send to you, so I need you to come up to Northern California. So I did, only to find that the papers were legal papers. We'd been served. We had 30 days to answer the complaint, and the 30 days had transpired. Therefore, a default judgment was entered against us for $385,000. Okay. So, of course, you take a look at it, and I thought I'd go through when you're served papers, typically there's an answer form. It's a generic form that gives you the opportunity to answer. And that is your opportunity to say, I disagree with this lawsuit. There are items which I know to be false in the claim. There are items which I don't know the truth of, but I assume them to be false. And you can put them in those two categories on the form, usually by reference to the number of the paragraph and explanation in the complaint. So I've often sat in court and heard people stand up and they're called before the judge. They've received the complaint, they've answered it, and they say, I agree with everything it's in it, I just don't have the money to pay. And the judge informs them, because they've agreed with everything in it, he has really no choice but to go ahead and find in favor of the plaintiff and against them. So recently I had occasion to, obviously in my case, I had to negotiate a setting aside of the judgment and to actually give me time to file an answer. In filing the answer, of course, I objected to a number of the assertions that were made, and I will soon have a trial date going forward. I have a friend who was served papers for a debt that he owed. He defaulted on payments of the debt was written off, and he was then giving a miscellaneous income report, so he would file the taxes and pay, because that is deemed income to him, the forgiven amount of debt. Nevertheless, he still continues to this day to get debt collectors who claim to have been sold that debt and are trying to collect. And these are huge mills that file hundreds of papers each day in the hope that you don't know your rights. and that they could collect some amount of money. Anything is better than nothing. It costs them about $400 to file the complaints. So they're taking a risk, but their assumption is that they can recover something. I had the occasion to help him with his answer, and some of the questions were information and belief that he had this debt and so on. And I looked at it like any lawyer would and said, I don't know what they believe, therefore I deny it on the basis I don't know the truthfulness of that statement, but also whether he's been in good standing in the state of California, whether he has the rights to this or not. The other half is the things that you know not to be true. My friend knew that he had not spoken to him, he had not agreed that he owed this debt, etc. But in so doing, all that does is put off the inevitable, which is eventually you're going to get a date, a hearing, and you don't lose by default. That's the time when you're going to have to evaluate what information you're going to need to seek. So for example, in this case, he really needs to get his tax information that shows that he paid taxes on the forgiven debt. Once the debt was forgiven, all right, it's really changed the terms in the contract, and it's really going to be difficult for the other side to prove that the right has been sold to them and not to others. He's simultaneously has gotten creditor notices from many companies over the same debt, and therefore kind of has him in a quandary. How do I know who I really owe, if I owe? And that's a legitimate question. So you're going to ask them to prove kind of a chain of custody that you owe this debt. The other side of the case is suing people. And what I would say, this is really where I've watched people go through long cases. I've watched them suffer weight gain, weight loss, health problems, etc. It truly is a situation of you win by not playing the game. Thank you.